to stay out of my head, stuck between my rights and my wrongs. Second guessing what I'm doing. Like, am I really there for my boy? Not enough, but if I'm paying child support, do they make it for time that I've lost? Whole time paying this court system. Can't even call my little man a game system, cause my checks be short. And if your bag too short, well, you had to miss a month. Slipping up, I gotta pick it up. Grind limitless, but it got your folks like, yeah, I hope you don't get caught. Like I missed the payments on purpose. Can you see I failed and I'm hurting? Ain't had no job, so no working. Or the job I work is not working.
Shalom, this is your Ark. Yah is magnified, coming back with another informative video. I titled this video, Government Contractors Have Sovereign Immunity Under the Yearsley Doctrine. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, let's get to it. Okay, guys, so this is going to be a quick video, okay? I'm not going to hold you all long. I just want to prove without a shadow of a doubt that you cannot sue the agency in federal court, you cannot sue its contractors in federal court, and you cannot sue these agents acting on behalf of the agency in federal court. They all fall in sovereign immunity, okay? So let's continue on giving you all this right knowledge, this right wisdom, and this right understanding, okay? So you all can have proper understanding, proper knowledge of what's really going on, and the reasons why I can't stress this enough to tell you all to stay out of these federal courts, okay? No matter what other channels are saying, if they believe that to be the case, let them. But for everybody that's watching my channel, you all will get the truth, okay? If everybody want to get this information and see this truth, I'm putting it up, okay? But like I stated before, you know, this is not my information I'm putting out there. I'm just putting up what the higher courts have ruled, okay? Until someone show me anything different from what the higher courts are saying, then, hey, I don't believe it, okay? And it's not that I don't believe it. It hasn't been done. You know, there's no evidence of anybody going to these federal courts, suing the child support agency and winning, suing the child support agents and winning, and suing the child support contractors and winning. It just don't exist, guys, you know. But like I said, have I become your enemy because I tell you the truth? No, okay? I'm telling you all the truth, like it or not, you know. The truth will make you free, though, okay? You have to get this right wisdom, this right knowledge, and this right understanding in order for you to get the remedy that you are seeking, okay? And stand out of federal courts is the first step. Okay, get your remedy out the state. The state is causing you injury. The state is causing you harm. The state is bringing you into these courts to enforce the duty of support. It's just that simple, okay? So now, let's pick this up. This has come from the 4th Circuit Court of Appeals, okay? I did not write this. I did not make this up. This is true. This is facts, okay? Until somebody show me where the 4th Circuit Appeals Court say anything different, then it is what it is, and the truth will be the truth. But let's continue. It states, the 4th Circuit decision clarifies scope of Yearsley's sovereign immunity to government contractors. Let's continue. It states, the United States Court of Appeals for the 4th Circuit recently clarified the breadth of the Yearsley sovereign immunity doctrine as it respects government contractors. Then it says, including that Yearsley may provide immunity against causes of action arising under federal law, not solely state law, ultimately acknowledging further protection for government contractors acting at the arguably lawful discretion of a government agency. Okay? So they just did what? They granted them sovereign immunity, acting underneath the lawful direction of a government agency. Okay? We know the federal government agency is what? The Department of Health and Human Services. Okay? The child support program is ran through the federal government. We know that. Okay? But the state is doing the enforcement. We know that. The child support agency is an arm of the state. We know that. How do we know these things? Because it's case law that we can pull up right now that further proves it. Like case law I'm showing you right now, further proving that these contractors do have sovereign immunity as well, according to the Yearsley Doctrine. Let's continue, though. It states, on April 24, 2018, the 4th Circuit affirmed a decision by the U.S. District Court for the Eastern District of Virginia dismissing a lawsuit alleging the contractor's violation of the Telephone Consumer Protection Act, TCPA. Then it says, based on the application of the Yearsley immunity doctrine and Cunningham versus the General Dynamic Information Technologies, Inc., Cunningham and several other similarly situated plaintiffs filed suit claiming that they received automated phone calls from General Dynamics Information Technology, Inc., GDIT, which advertised the commercialability of health insurance without their consent. In dismissing the suit for lack of subject matter jurisdiction, the district court relied on a rule promulgated in Yearsley versus W.A. Rawls Construction. Then it states which which immunized government contractors from suit when the government authorized the contractor's actions and the government validly conferred that authorization. Okay, so again, contractors are immune from suit. It's just that simple. But let's continue. Under the doctrine of sovereign immunity, the United States is immune from private civil suits absent an express waiver. So we know in order for you to have to file suit against the United States, the United States must waive the sovereign immunity in order for it to be sued, which they haven't done. Same thing with the states, its agencies, its contractors, and its agents, okay? But let's continue. Yearsley provides that this immunity can also apply in certain circumstances to agents carrying out the sovereign's will. You see what I mean? So, again, if they're acting on the sovereign's will, who are they claiming to be the sovereigns? The states and the United States. Okay, let's continue. I.e., government contractors. Specifically, a government contractor will not be subject to suit if 1. The government authorized the contractor actions, and 2. The government validly conferred that authorization, meaning it acted within its constitutional powers. Okay, so again, this is more proof, more facts, more truth. This has nothing to do with me making this stuff up. No, I'm not making this stuff up, guys. So again, people wonder why they go to these federal courts and getting nothing but horrible results. Why? Because they don't do their research. They don't have understanding of what they're